Oh, there's. All right, so this is, are you Tracy Straight?
Yes, I am, Your Honor.
Okay. Good afternoon. Counsel, you want to state your appearances, please?
Anthony Julian on behalf of
Liz Elliott on behalf of Tracy Straight.
All right, and we scheduled this for a competency hearing. Ms. Straight has previously been held by this court to be incompetent to stand trial and was sent for treatment. I received a report by Dr. Gren dated 8/8/2025, indicating that the opinion that from the forensic center that she has been restored to competency. So we scheduled this for a competency hearing within the statutory time frame. Do the people have any objection to the court's receipt and consideration of the report?
No, Your Honor.
Does the defense?
No, Your Honor.
Are there any additional proofs on the question from the people?
No.
Any additional proofs on the question from the defense?
No, Your Honor.
And based upon that, I would find that Ms. Straight is competent to stand trial and the case shall continue to the next stage of the criminal process. It did appear based upon the report that she is receiving medication to maintain competency. So I will check the box on the state form indicating that the defendant, in order to maintain competency to stand trial, shall be administered appropriate medication pending and during a trial. So I guess then that brings us, we need to schedule this for a docket call, probably in September. Set it for September 30th at 2:10 p.m. And Mr. Juliet, do you know then, what happens logistically then? Is she going to remain at the hospital pending that, or is she going to need to be returned to the Sheboygan County Jail?
It's my understanding she's going to need to be returned.
Okay. All right. Anything on that from the defense?
Well, Your Honor, in speaking with Ms. Straight, she mentioned something called a maintenance order that would allow her to stay at the forensic center pending trial. And I am imagining that would be so that she can continue with her therapy and continue to receive the medication she needs to maintain competency. So we would ask that the court would order that. If the court's not inclined to order that and she's transported back, we would be asking that Ms. Straight be placed on a tether if the court's concerned for her risk of failing to appear. A tether could assure the court that she will appear when she's directed to. She has a mother who's in very poor health, and she would like to be able to get back here and see her.
Well, I mean, I think she's been committed for treatment to see if competency could be restored. There are statutory limits to the time that she can be under that order, because it's not really a mental health treatment order through the probate court where she would have all sorts of rights to review. So just looking at the applicable statutes, let's see, redetermination.
And excuse me, Your Honor, this is Ashley Kelly, court liaison here at Walter P. Ruther. May I interject?
Yes, please.
Yes, so you are totally correct. Here at Walter Reuther, we have patients here until they are restored competent. And just as in Ms. Straight's case, once she is deemed competent, we obtain the finding and order on competency, and then she will be returned to jail.
Okay. Yeah, that's what I thought. I'm looking at the statutes. There's a limit to how long, because she's being held at that hospital involuntarily. I understand she's saying now maybe she'd like more treatment, but she was sent there involuntarily based upon my authority under the mental health code for incompetence to stand trial. Now that she has been found competent, I don't think that my order allows that treatment to continue there. The hospital, if they saw fit, have statutory authority to petition for treatment. They're probably not going to do that. The prosecutor's office or family members would have authority to petition for treatment upon Ms. Straight's return to the jail. If she wants to seek voluntary mental health treatment, I'm sure the jail can facilitate, an assessment for the needs and appropriateness of that. In this case, her bond had been revoked for an absconding from the felony bond. So I'm not going to reinstate the bond at this time, just to have a hospital downstate cut her loose, and who knows how she can get back. We'll have the sheriff's department go and retrieve her, return her to our jurisdiction, and then we'll have the docket call on September 30th. In the meantime, as soon as she's returned, if the defense wants to file any motions prior to the 30th to review either the bond or any treatment needs, you can certainly notice up any such motion. Okay. All right, thank you, ma'am, for that clarification as well.
All right, thank you. And then can you guys, once that finding and order is established, can you please send a copy over to Walter Reuther, because that is our documents to be able to release her to the sheriff.
Okay, very good. Very good. We'll do that.
Okay, thank you.
Thank you.
Is there a chance that I could speak with my attorney before we're exited out?
Well, I could do a breakout room but your attorney on the underlying case is Mr. Gilbert, and he could not be here today, and Miss Elliott is assisting just for today. Did you want to speak with Miss Elliott, or you want to talk to Mr.
Yes.
Gilbert?
I would like to speak with Miss Elliott.
Do you have other matters
I
downstairs?
do. They're doing arraignments in district court right now. So.
All right, Miss Elliott is her attendance is required in another court right now, so we're not able to do that. She can see if she or Mr. Gilbert are able to talk to you down there, but you should pretty shortly be brought back up here, and they'll have easier access to speak with you at that time.
Okay, thank you.
We'll see you soon.
All right, let's talk about that. Judge Aaron J. Gauthier ran this competency hearing with his usual measured hand firm when needed, but never losing that steady, methodical tone. From the start, he made it clear this was a statutory box-checking exercise. The court had received a report from Dr. Gren declaring that defendant Tracy Straight, previously found incompetent, had been restored to competency with the help of medication. Both sides accepted the report without fuss, and the judge wasted no time in formally finding her competent to stand trial. The one wrinkle was the defense's request to keep Miss Straight at the forensic center on a maintenance order so she could continue treatment rather than be shipped back to the county jail. Counsel framed it as a way to preserve her stability and allow her to visit her ailing mother, even suggesting an ankle tether as a fallback. Judge Gauthier, however, gave a clear legal explanation. The forensic placement was strictly for restoration, not ongoing care now that competency had been restored. The law required her return to jail unless a separate petition for mental health treatment was filed. The court liaison from Walter P. Reuther Hospital backed him up, confirming the policy and procedure. The defense's tether idea didn't gain traction either, especially since Miss Straight's bond had already been revoked for absconding. The judge stuck to the rules: no bond, reinstatement, sheriff retrieval. Docket call set for September 30th and kept. The door opened for future motions on treatment or bond if the defense wanted to try again. As for the atmosphere, it was calm but brisk, with a few moments of logistical back and forth about paperwork and transport. Even Miss Straight's last-minute request to speak privately with her stand-in attorney got handled. Professionally, the judge explained her counsel's scheduling conflict and directed her to coordinate with either attorney once she was back upstairs. No drama, no raised voices, just a clear example of how a judge can keep things moving while respecting everyone's role. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts. In the comments below, I read everyone.